As watchers of my YouTube channel know, I'm fascinated and love drafting of legislation. So I have some additional California drafting notes to share as I make my way through bills in the second house, through the policy and into the fiscal committee. And I continue every year to come across interesting provisions contained in these bills. And so I put together some additional drafting notes, being the legislative geek that I obviously am. So this first one is an expansive statement. It says, the legislature finds and declares that neither the original provisions of this section nor any subsequent amendments to it were intended to create a private right of action. However, nothing in the subdivision shall restrict or expand the existing right of any party to seek relief from non-compliance with this section pursuant to writ of mandate. I don't know, but this provision reminds me of the old saying, giveth with one hand and taketh with the other. When we're talking about the rights of a party, I don't think we should rely upon findings and declarations to specify those rights, but rather I think it should be contained in actual statutory language. With the first sentence in this legislative finding and declaration, shouldn't the same provision be required in the future? How does a current legislature think it can speak for all subsequent amendments for any future legislature? Another provision that has some broad application, this one says, for purposes of any code or statute, a national or regional accrediting agency recognized by the United States Department of Education as of January 1, 2025 shall retain that recognition until January 20th, 2029, provided that the accrediting agency continues to operate in substantially the same manner as it did on January 1, 2025. Now, I've seen this type of language for a specific provision of law, for example, but this bill's language is much broader. It says for purposes of any code or statute. Statute is a broader term as it refers to both codified and uncodified language, whereas the code contains certain codified statutes by subject matter. This is one where we've seen variations of this language. This one says the remedies provided by this section are cumulative to each other, and the remedies or penalties available under all other laws of the state. Now, depending on one's point of view, this statement could be problematic because it specifies that whatever remedies, such as civil penalties, are contained in the current bill, they're in addition to rather than in place of existing remedies elsewhere. We've also seen some variations of this language. This bill is not intended to modify or weaken existing protections. In the event of a conflict between the provisions of this bill and any existing state law or regulation, the more stringent provision shall prevail. This is also a provision we see in California statute on occasion, although such conflict should be addressed in a new bill, in my opinion. As a general rule, a more recent statute will take the place of an earlier enacted statute that's in conflict, for example. However, this clause will require an enforcement agency or a court of law to first determine is there a conflict and then determine which provision is more stringent and then apply that more stringent provision to the particular factual circumstances. I also came across an interesting grant of rulemaking authority. It says any rules or regulations related to the panel shall be formulated by the Attorney General in collaboration with the chairperson of the panel. Now, while statutes often provide narrow or perhaps broad or generalized rulemaking authority, in this particular bill provision, the authority is granted to the state's AG, but the AG is required to collaborate with a panel chair located elsewhere in California state government. I came across what I view as a good plus section. This is an effort to apply a bill's provisions to all cities. Now, normally we find a simple statement that says, for example, addressing a crisis is a municipal affair. It's of statewide, I'm sorry, it's not a municipal affair. Instead, it's a matter of statewide concern, and therefore this particular provision of law shall apply to all cities, including charter cities. That's a requirement that's imposed upon legislation if it wants to be applied not just to general law cities, but also charter cities. But this particular one includes a half a dozen findings and declarations. And so after we make our way through those half a dozen findings and declarations, then we see the standard statement. Therefore, addressing the housing crisis and the severe shortage of housing is a matter of statewide concern and is not a municipal affair, as that term is used in Section 5 of Article 11 of the California Constitution. Therefore, Section 1 and Section 2 of this Act, amending two provisions of the Government Code, apply to all cities, including charter cities. So again, in most instances, those last two sentences I read are the only ones included in a bill, meaning it's just a statement that the bill applies to all cities, including charter cities. Now, perhaps that's sufficient under the law, who knows? I think the better approach is drafting to include a brief explanation of why the bill should apply to all cities, including charter cities. And that has occurred in this example. There are multiple reasons cited through legislative findings and declarations why the bill's applicability is not just to general law cities, but also to charter cities. I'm seeing a lot more severability clauses this year, 2025. If a bill contains a severability clause, it's found in two places. First, there's a simple statement contained in the Legislative Council's digest. It simply says, this bill would declare its provisions to be severable. The second is found in the text of the bill in either codified or uncodified language. And those read, the provisions of this act are severable. If any provision of this act or its application is held invalid, that invalidity shall not affect other provisions or applications that can be given effect without the invalid provision or application. There is a question about whether or not severability clauses are necessary. As a general rule, the courts will sever an unconstitutional provision that's unlawful, regardless of whether there's a severability clause. Nonetheless, the courts will certainly look first to see whether there's a severability clause and rely upon it. But again, I think there seems to be a growing number of bills in the California legislature that contain these severability clauses. By June of 2025, I had already counted at least 116 bills with a severability clause. Some bills have revisions, some bills have corrections. You'll see it at the top above the amendments. It'll say revised and with a date or corrected with a date. And then at the very end of the bill, past all the language, it'll say correction, such as in the heading, or revision. Well, I found a bill in 2025 that had both revisions and corrections. So under the joint rules of the Assembly and Senate, the Office of Legislative Counsel is actually authorized to make technical changes to a bill, which means the formality of adopting amendments is not necessary to revise or correct provisions in a bill. And this is set forth, for example, in Joint Rule 8.7, titled Errors in the Digest, among other places. So in the bill that I came across, it contains both corrections and revisions to the heading. And headings of bills are addressed in Joint Rule 10.7 and deal with authorship of a bill. Another bill that I came across in 2025 had a legislatively created exception to the Administrative Procedure Act, which I personally despise. This bill said, notwithstanding the rulemaking provisions of the Administrative Procedure Act, and then cited its provisions in the Government Code, the State Department of Social Services shall implement this act through an all-county letter or similar instruction. From my perspective, and I've said this before, I think that any exceptions from the APA, our Administrative Procedure Act, are unjustified. All agencies and departments and boards and commissions and bureaus should all be required to follow the procedural requirements imposed on executive branch rulemaking. And the example I just cited from a bill is one in a long line of unfortunate provisions where the legislature continues to give exceptions to the APA to the executive branch I really think that creating these exemptions from the APA cuts out public participation in the rulemaking process, and it's contrary to the public interest and really contravenes efforts to expand transparency in this form of lawmaking. The last interesting example in drafting of legislation was this. I found a different way of creating a special statute designation. It says the legislature finds and declares that a special statute is necessary and that a general statute cannot be made applicable within the meaning of Section 16 of Article 4 of the California Constitution because of the unique circumstances described in Section 1. Now, Section 1 of this particular bill contains 13 legislative findings and declarations, which is obviously a large number of findings and decks. So the approach that's being taken in this bill is to cross-reference all those legislative findings and declarations to explain or justify why a special statute designation is required with this bill. And I really like this approach. I think it's definitely better than simply a simple statement that usually forms the basis for the special statute, just a blanket affirmative statement by the legislature without any explanation. I think I've explained that my view is based upon several trial court cases in which judges have reviewed special statute designations, and I'll just say, haven't been enamored, perhaps, by that short statement that accompanies most special statute designations. So while the bill's plus section should contain a detailed explanation in my mind of why a general statute cannot be made applicable to a particular bill, I think in this case, cross-referencing quite a few legislative findings and declarations is probably a good approach to take.